Hello YouTube. Today is July 10th, 2015. Head court today at 11 a.m. Proceedings are to evict me from this house, this unfinished house you see behind me. Today we filed an answer in the eviction proceedings because we had to answer to the eviction, and eviction proceedings are supposed to give both sides an opportunity to present information to the court so the court can make a decision on whether or not to evict or to not evict. Today, Judge Janes claims that our answer should have been filed somehow in proceedings previous to the eviction proceedings that are non-existent. Michigan is a non-judicial foreclosure state, and the bank does not need to initiate proceedings in court to foreclose. They file a notice of advertisement, notice of sheriff's sale by advertisement. And in Michigan, that's good enough. I guess a lot of different states are like this, but Michigan is a non-judicial foreclosure state, and Judge Janes today in court told me that I should have filed an answer, a similar answer with similar issues in non-existent previous proceedings. You know, if there were any more ways to bastardize due process here in Michigan, it's going to be hard for me to imagine after seeing what I've seen. I have to file something in previous proceedings that don't even exist. Anyways, if you can comprehend that, let me know what I'm missing here. Even if there were previous proceedings to these eviction proceedings to evict me from this house, the one you see behind me, we weren't noticed. Okay, nobody was noticed. The proceedings, if any, are a nullity. But there are no proceedings. And Judge Janes today, Judge Janes, J-A-N-E-S, denied us due process under color of law. That's a big thing. In addition to, or as part of the issues that we brought up today, were the fact that in the public notice, the published notice of the sheriff's sale, the bank put the wrong redemption period. The property we're on is over 3 acres, residential, under 4 units, subject to a 12-month redemption period. Additionally, this property is agricultural and is subject to a 12-month redemption period for those 2 criteria right there. And we brought up the redemption issue, and Judge Janes said that is something that we should have brought up in previous proceedings that do not exist. Hey, this is our due process here in Michigan. And even though the results today were no different than I expected, it's kind of interesting now because Judge Janes and I hadn't had any interactions previous to this that I'm aware of, and today he just fully vested himself as one of the terrorist judges here in Isabella County. Okay, you know, when you're talking about taking away somebody's home, you should err on the side of caution that things are happening right and that the procedures are being followed, specifically with regard to notice. And specifically with regard to, you know, the fact that redemption periods are part of Michigan law. Okay, it's right in the statutes. And there was a specific reliance upon myself and my family that when we purchased this property, it was subject to a 12-month redemption period. So, you know, these are things that can't be overlooked. Now, what Janes did today was he entered an order for possession on our property. Essentially, he gave the bank right to possess. Now the bank needs to file for a writ of eviction. And then Janes will presumably enter an order of eviction and give us X amount of days to get out. But you can see where things are headed here. You can see where things are going. And in the next video, I will tell you my stance on that and how we are going to proceed. We've lost our judiciary, folks, completely in Isabella County. I'm assuming that the majority of counties in Michigan are in similar shape based on the research that I've done. One clear indicator is the use of administrative rules to govern the people. That's one issue that I'm trying to, knock out of the park here in Isabella County. Judges are not allowed to create laws, essentially. And when a judge creates an administrative rule under the authority granted a chief judge or trial court judge in the state of Michigan, it's granted under Michigan Court Rule 8.112. And the trial judge or chief judge is allowed to make administrative rules for the internal operations of the courts themselves. And obviously, when Paul Chamberlain, as a terrorist, implements administrative rule, creates administrative policy through an administrative rule, specifically 2015-2, the exclusion of cell phones and all electronic devices from the courtroom, and imposes that on the public at large, or the general public, we the people, and specifically excludes the court staff and bar members, etc. That's just totally wrong. Totally wrong. Anyways, enough here. That's 7 minutes already. And if you like what you're seeing, subscribe. If you want more information, catch the next video. Thanks again.